5 seconds to go. Start. These are the bare facts triggering the challenge by the appellant to the order of penalty, imposing a cut in pension for the remainder of the period he would receive pension, which partially succeeded before the division bench of the High Court and was modified to a period of 5 years. Before we embark on a judicial review of the decision taken by the disciplinary authority to penalize the appellant and examine the correctness of the impugned order, we need to remind ourselves of the well settled principles relating to interference with decisions taken in pursuance of disciplinary proceedings to discipline and control errant employees. Certain generic principles governing interference with orders of punishment that are passed following inquiry proceedings have evolved over a period of time. Law is well settled that an administrative order punishing a delinquent employee is not ordinarily subject to correction in judicial review because the disciplinary authority is the sole judge of facts. If there is some legal evidence on which the findings can be based, then adequacy or even reliability of that evidence is not a matter for canvassing before the High Court in a writ petition filed under Article 226 of the Constitution. However, should on consideration of the materials on record, the court be satisfied that there has been a violation of the principles of natural justice or that the inquiry proceedings have been conducted contrary to statutory regulations prescribing the mode of such inquiry, or that the ultimate decision of the disciplinary authority is vitiated by considerations extraneous to the evidence and merits of the case, or that the conclusion of the disciplinary authority is ex facie arbitrary or capricious, so much so that no reasonable person could have arrived at such conclusion, or there is any other ground very similar to the above, the High Court may, in the exercise of its discretion, interfere to set things right. After all, public servants to whom Article 311 of the Constitution apply do enjoy certain procedural safeguards, enforcement of which by the High Court can legitimately be urged by such servants depending upon the extent of breach that is manifestly demonstrated. It would further be of immense profit at this stage to consider a specific principle which is tailored to the particular situation and could clinch the issue. The Constitution Bench of this court, speaking through Honorable P.B. Gajendra Gadkar, Judge in Union of India versus H.C. Goyal, laid down a specific test which could be applied if a contention were raised that the conclusion is based on no evidence. Relevant passages from the said decision, evincing one of the two questions arising for decision and the answer thereto, read as follows. Two short questions of law arise for our decision in the present appeal. The first question is, and the other question is, whether the High Court, in dealing with a writ petition filed by a government officer who has been dismissed from government service, is entitled to hold that the conclusion reached by the government in regard to his misconduct, if not supported by any evidence at all. As our judgment will show, we are inclined to answer both the questions in the affirmative. Thus, the appellant, the Union of India, succeeds on the first point but fails on the second. It still remains to be considered whether the respondent is not right when he contends that in the circumstances of this case, the conclusion of the government is based on no evidence whatever. It is a conclusion which is perverse and therefore suffers from such an obvious and patent error on the face of the record that the High Court would be justified in quashing it. In dealing with writ petitions filed by public servants who have been dismissed or otherwise dealt with so as to attract Article 311(2), the High Court under Article 226 has jurisdiction to inquire whether the conclusion of the government on which the impugned order of dismissal rests is not supported by any evidence at all. It is true that the order of dismissal which may be passed against a government servant found guilty of misconduct can be described as an administrative order. Nevertheless, the proceedings held against such a public servant under the statutory rules to determine whether he is guilty of the charges framed against him are in the nature of quasi judicial proceedings, and there can be little doubt that a writ of certiorari, for instance, can be claimed by a public servant if he is able to satisfy the High Court that the ultimate conclusion of the government in the said proceedings, which is the basis of his dismissal, is based on no evidence. In exercising its jurisdiction under Article 226 on such a plea, the High Court cannot consider the question about the sufficiency or adequacy of evidence in support of a particular conclusion. That is a matter which is within the competence of the authority which deals with the question, but the High Court can and must inquire whether there is any evidence at all in support of the impugned conclusion. In other words, if the whole of the evidence led in the inquiry is accepted as true, does the conclusion follow that the charge in question is proved against the respondent? This approach will avoid weighing the evidence. It will take the evidence as it stands and only examine whether on that evidence illegally the impugned conclusion follows or not. Though we fully appreciate the anxiety of the appellant to root out corruption from public service, we cannot ignore the fact that in carrying out the said purpose, mere suspicion should not be allowed to take the place of proof even in domestic inquiries. It may be that the technical rules which govern criminal trials in courts may not necessarily apply to disciplinary proceedings, but nevertheless, the principle that in punishing the guilty, scrupulous care must be taken to see that the innocent are not punished applies as much to regular criminal trials as to disciplinary inquiries held under the statutory rules. It also needs to be emphasized that although the traditional concept of natural justice comprises of the two rules that prohibit anyone from being condemned unheard and anyone from being a judge of his own cause, jurisprudence on natural justice principles have been a distinct shift ever since the decision in Menka Gandhi versus India constitutionalized principles of natural justice as held in Madhya Mem Broadcasting Limited versus Union of India. Drawing inspiration from such authorities, it would be apt to observe that in relation to disciplinary proceedings subject to just exceptions, natural justice would envisage observance of procedural fairness before holding a public servant guilty of misconduct and imposing a punishment on him for such misconduct. While it is true that principles of natural justice supplement and not supplant the law, such principles have been declared by this court to be a constituent feature of Article 14. Validity of any disciplinary action, whenever questioned, has to be tested on the touchstone of Articles 14, 16, and 21, as well as Article 311 2, wherever applicable. Stop.